Welcome to another full episode of MissTrial, joined by my co-hosts Kathleen Rice and Danya Perry. I'm Karen Friedman Agnifilo, or KFA, as many people like to call me. So great to be here today to talk about so much that's going on at the intersection of law and politics. The four topics that we're going to talk about today are cases that are happening, one of which is this strange dismissal, lawless dismissal of Judge Cannon did of the Mar-a-Lago classified documents case. Jack Smith's announcement that he's going to appeal that, and where that stands, and what that means for other special counsels, and what that means for his other cases, Trump's other cases. We're going to talk about that. Can't wait to hear what you guys think about that. And also, just really interesting that after all these years, Joe Biden is considering proposing significant reforms to the United States Supreme Court. I'm not surprised, given how lawless and strange their decisions have been lately, and just creating this new legal standard that one person, one human being, is above the law, the president of the United States. So I'm not surprised that he's considering this. I think a lot of people was hoping that this would have been done a while back, but this is something that has to happen. And so he's considering those, and we're going to talk about that. Also, big news that Senator from New Jersey, Senator Menendez, was found guilty, and that was in the state of New Jersey for receiving bribes, as well as what is going on in Georgia in the Fani Willis January 6th case, and where that stands. So there's a lot going on, despite it being the dog days of summer when judges take vacations and courts are usually much slower. We're in that time, yet so much is happening. How you guys doing? How are you, Kathleen and Danya? It's good to see you.
Doing great.
Hanging in. I'm good. I'm in the office today all by myself. I miss you guys.
Oh, God.
I know. So why don't we jump right in and talk about what everyone's thinking about, which is the Mar-a-Lago case? Because, look, since we last recorded MissTrial, Jack Smith has officially announced that they are going to be seeking an appeal of this ridiculous decision. And so let's just kind of talk about the Mar-a-Lago case and where that stands, given what has happened. And just to kind of remind people of where that case is, this was the case that has been indefinitely delayed intentionally by Judge Cannon. She wouldn't set a trial date. She didn't rule on many motions, substantive motions that have been before her for months, which is so unusual. She keeps just adding new hearings and having more briefings and oral arguments, and then she doesn't decide. And it's been frustrating for a lot of people, because a lot of her rulings, when she does rule, are so outside the bounds of what the law says and what's normal practice, that a lot of people have been saying, why hasn't Jack Smith appealed? Why hasn't Jack Smith sought her to bump her off the case? And the reason is because she doesn't make any rulings that he can appeal, right? It just doesn't seem to happen that she will actually make some kind of ruling to be appealed. And to be fair, the two times that Jack Smith has appealed decisions that she's made, the 11th Circuit has smacked her down and reversed her. So I think that the 11th Circuit is a 3 strikes and you're out kind of place. And so we'll see if they take that as an opportunity to bump her off the case and give it to another judge. There's a couple of silver linings here that I want to talk about. Number one, this 93 or 94, whatever page decision that she wrote is something to appeal. So that's a good thing, right? She finally gave them something. It wasn't just one of those, she does a lot of these couple of line minute entry orders where that's where she does rulings on her docket. And those aren't real decisions. This is a real decision. This is a real analyzed decision that has a lot of faulty analysis and can be appealed. And what was interesting to me is how the Department of Justice said, I think within 24 hours, that that they gave approval to Jack Smith to appeal this decision, which is significant for the following reason. One of the things that Aileen Cannon wrote in her decision was very much the substantively very much talking about the fact that the special counsel is not proper under the law, right? She specifically said that it goes against the appointments clause. And the appointments clause in the Constitution talks about how it has to have the advice and consent of the Senate in order to approve any positions, any officers, right? Unless there's a statute in place that authorizes something different. And there are two statutes here that every court that's ever relied on or sought to analyze this issue about special counsel, there's two statutes that they rely on, 28 United States Code 510 and 515B. And what was interesting and the main thing, the reason why the appeal was interesting to me, or this notice of appeal, was because 28 United States Code section 510 reads, the Attorney General may from time to time make such provision as he considers appropriate, authorizing the performance by any officer, employee, or agency of the Department of Justice of any function of the Attorney General, main justice, or of the Attorney General, period, full stop. Okay, that's what the statute says. What I loved about the appeal was what they said was, the spokesperson for the special counsel, Peter Carr, said, the Justice Department has authorized the special counsel to appeal the decision. What that is saying is, I work for the Justice Department. I'm not outside of this. I am within Section 510 because, again, Section 510 says the Attorney General may, right, authorize the performance of any employee or agency of the Department of Justice or any function of the Attorney General. So that is why I think it's important that in that one sentence, they were basically signaling this is part of the Department of Justice. It takes the wind out of her sail. And, you know, this was the main reason why this is okay, is this section. And I think she only spends like 2 or 3 pages of her 93-page decision even discussing these two statutes, right? All she writes is essentially that you know, this Jack Smith doesn't work for the Department of Justice. He's outside the Department of Justice. Therefore, it doesn't comport with Section 510. And Section 515B says each attorney specially retained shall be commissioned as a special AG or special attorney and take an oath by law. And she says, no, that's really just refers to the United States attorneys. That doesn't count here. But this is, you know, she's trying to say he's independent, which he's not. He's a special counsel, which is clearly authorized in the statutes, and he's paid by the Department of Justice. And, you know, there's no doubt he's an arm of and has to answer to the Department of Justice like he did to seek permission to appeal. And so I think as a result of how they're playing this, and today they filed notice with Judge Cannon letting her know that they're appealing this, which they are required to do. I think that the 11th Circuit will very, very quickly consider her to be a rogue outlier again, will smack her down, will potentially take her off the case. But then, of course, what will the Supreme Court do? And the thing I'll say about the Supreme Court is, in the immunity decision that came out July 1st, Justice Thomas, even though this issue was not briefed or before them, Justice Thomas wrote a concurring opinion where he essentially was speaking to Judge Cannon. And we talked about this. We predicted this, that this was going to happen, speaking to Judge Cannon, essentially saying, you know, I know that you just had oral arguments on special counsel. I know you allowed people who aren't even parties to come in and make oral arguments and submit papers, the amicus curiae or friends of the court. I know you had that. So clearly you're looking at this. So I'm going to spoon feed this to you and give you permission, Judge Cannon, to do this. So there was no doubt when we read this that is what she was going to do. We predicted this, and she cited to Justice Thomas's concurrence. And the last thing I will say before I want to hear what you guys have to say, I thought it was interesting in his concurrence that it was a solo concurrence, that not a single other Supreme Court justice signed on to that. So I don't know that it's a done deal that once this gets past the 11th Circuit and she's reversed and this goes to the Supreme Court, I don't know what they'll do, but this is another example. And by the way, she drops it on the first day of the Republican convention. I mean, come on, if that's not a partisan signal, what is? So that's where we are with Mar-a-Lago. It's going to be appealed, and I hope the 11th Circuit smacks her down quickly. Love to hear your thoughts.
Well, I'll just jump in on the last thing you said. I'll jump in on that first. I never want to kind of predict anything with this sitting Supreme Court, because usually it comes out the opposite way that I think under the law it should, at least in the past couple terms. But I do think we should be able to read something into the fact that was a separate concurrence of one. 1/9 of the court said that, and there were different opinions. Obviously, Justice Amy Coney Barrett had a separate concurrence where she said that she would rule differently from the majority on a very important piece, which is the Supreme Court, under Justice Roberts, his majority opinion, which said, quite shockingly, I think, not only, is the president largely immune for anything that is official or that even could be considered official, but that evidence of these acts cannot even be admitted into evidence in a prosecution against the former president. And she dissented from that, I think, very notably. And so, the judges were not, in lockstep necessarily, and had others wanted to join in that concurrence, of course, they would have been free to do that. So, but I will note on the other side of that, of course, that issue was not in contest in the immunity issue that was in front of the court. So Justice Thomas went out on what in the law we call a frolic and detour, which is just going out on a limb and saying something, we also call it dictum. It is not law. It has nothing necessarily even to do with the case at bar, but he wanted to say what he wanted to say. And he, of all the justices, has been known to do that. Famously in the Dobbs decision, he did that as well, calling into question, other settled law. So I want to believe that the 11th Circuit will reverse Judge Cannon as it has so handily in the past. And that if then that is appealed, as it surely will be, I shouldn't say if, I should say when, that only Justice Thomas, will go the way that Judge Cannon has. But I don't, the optimist in me has been dead for some time, so I don't want to, read too much into that concurrence of one.
Oh,
Don't
don't kill your optimism.
Exactly.
Optimism. I think that it's so important that I hope that people are paying attention to this, because I think what this shows is the incredible power that judges, especially federal judges and Supreme Court justices, have in this country. They have the power to not just decide how they're going to interpret the law, when they're going to, the timing of it, but especially now when we're talking about, July, August, September, October, November, 4 months away from a presidential election, to say nothing of elections that will determine what party is in control of the Senate and the House, which is equally as important, another branch of government. But the irresponsibility of that I hope the general public sees, that it appears that they're trying to keep people from seeing the underlying facts, how bad these cases are, that a sitting president on the way out the door kept, documents that did not belong in such an unsecure setting and was showing it to people randomly at his country club in Palm Beach. I mean, it's just really kind of crazy. And, it just gets to this whole push that, certain parties are making to, instill this level of skepticism and, pessimism, quite frankly. You use the word optimist before, Danya, but it really is, people are very pessimistic that the rule of law matters anymore. And I think that is, one of the very awful byproducts of all of this.
Yeah, I mean, public support for the Supreme Court and, belief that they are actually bound to uphold the law, it has declined precipitously, within the past couple of years. And, it's decisions such as the ones we've been seeing that, that go there, which probably is a great segue, Kathleen, to our next topic. And I mean, there's so much more to say about this. I guess I'll just one other footnote, Karen, to one other point you said, and maybe it's the other side of the coin to give it a little optimism. I mean, as much as Judge Cannon and the Supreme Court have been slow walking, Jack Smith has been acting with all deliberate speed. And you mentioned, Karen, that he's already noted that he will appeal the ruling. And I just want, people to understand what that means. So as you pointed out, he got permission from the Attorney General, and it was kind of pointed, perhaps a jab. But we know from people who have spoken, people who have worked, say on the Mueller special counsel team, that everything went up to the Attorney General. There, of course, Jeff Sessions had recused himself, but that, things were in fact vetted. So these are people, these are special counsels that work under the auspices of the Justice Department, no question. But here in this case, to get permission, within 24 hours, there's a lot that goes into that. It's not just an automatic thing, that this Jack Smith is acting as quickly as he can. And as I mentioned last week, the 11th Circuit also has acted really quickly with respect to other appeals in this case. So I'm hoping that they don't take a cue from the Supreme Court, dragging its feet as they did on the immunity, and that they'll act with the same kind of haste, properly so, that they have in the past, on this appeal. But then, of course, we'll have the Supreme Court, which can take its time. It doesn't meet again until October. So, no one thinks that this is going anywhere soon, but at least, the prosecution and the government is pushing. So it's not content to just sit there and cool its heels. So we will see how quickly that gets taken up.
And one other silver lining, too, is that Judge Cannon didn't make all the substantive rulings that have been before her. So they aren't, quote unquote, law of the case. And whatever judge, assuming she gets bumped, whatever judge isn't stuck with her rulings that are just ridiculous regarding the case. So she didn't rule on immunity. She didn't rule on the Classified Information Procedures Act. She didn't even set a trial date. There's so many motions that were outstanding that weren't ruled on. So I think that's interesting too.
You guys, there's always a silver lining.
Yeah, see, cause for some optimism. All hope is not dead. But just so people understand, there's certainly, you said, assuming that she gets bumped, that, it's a big move, right, for a circuit to push a judge off a case. Here, I think we've kind of made the argument that we think if ever there was cause, this would be it. It's not just the court, the appellate court doesn't have to find actual bias, but the appearance of prejudice or bias, or the inability perhaps to look past, previous rulings, that's what the court will look to. So they don't even have to find you, Judge Cannon, are in fact actually biased. They just have to say, look, enough is enough. We've reversed you before. This doesn't look good. There is a concept of kind of what looks good. It's the appearance. And, we can talk about that when we talk about the Fani Willis case in Georgia and that disqualification motion that is now going up on appeal. But there, the judge found there was no actual showing of bias, but there was the appearance, and that does matter, and that will be a live issue on the appeal. But I jump ahead.
All right.
Yeah.
But it was a great segue to the Supreme Court that I don't want to miss out on. So, well, Kathleen, take it away.
Speaking of the Supreme Court, Joe Biden, I believe it was on Saturday, was on a call with the Congressional Progressive Caucus, which is a group within the House. And I can read to you exactly what he said. He said, "I'm going to need your help on the Supreme Court because I'm about to come out. I don't want to prematurely announce it, but I'm about to come out with a major initiative on limiting the court. I've been working with constitutional scholars for the last 3 months, and I need some help," is exactly what Biden said. Now, just for a little background, this issue of like court packing, what are we going to do with the Supreme Court, really, really kind of was brought to the public awareness. I would say back in 2016, when in February of that year, so this is Obama as president, Hillary and Donald Trump running for president. And in February of that year, Justice Scalia dies. 9 months before Election Day. And Mitch McConnell, who was in charge of the Senate at that time, and they're responsible for, passing on, judicial appointments, Supreme Court justice appointments, said at the time, I think it's really important that we wait to have this person, Scalia, replaced, because there's going to be a new president in January, and that person should have the decision about who should make the appointment going forward. And people just thought it was just a rank political decision to take away from President Obama the ability that all presidents have to replace an empty seat on the Supreme Court. Now, mind you, 9 months where there were only 8 justices. Now, compare that to what happened in 2020, in September of 2020, when Ruth Bader Ginsburg passes away. And Donald Trump is president, and Mitch McConnell is still in charge of the Senate. And he says, we've got to right away. It's very important we fill this seat as quickly as possible. This was, Donald Trump running against Joe Biden, because we can't leave this seat empty for even 2 months. So, the rank hypocrisy of those two decisions just highlighted, I believe, for the general public, how important it is, how important the Supreme Court is, and how the appointments get done. So just for a little history, Article 3 establishes the Supreme Court, and it also gives Congress the power to decide the number of justices on the Supreme Court and issues like their compensation. So there has been, court packing, right? Deciding how many people are going to be on the court ever since the country has been in existence. And since I think the mid 1800s, 1860, in that time frame, the number has been set at 9. And we've been talking about court packing. President Biden has said he is opposed to that. And when he became president when he was sworn in January of 2021, one of the first things that he did was he set up a bipartisan commission to study the issue of what should be done with the Supreme Court, give us recommendations about what we can do. There were a lot of people saying we should term limit them. Again, these are lifetime appointments. We should set up an ethics code for them that they are bound to adhere to. That became really big because of all of the public becoming aware of all the gifts that Justice Clarence Thomas had accepted from big, heavy-hitting Republican donors over the years, none of which was disclosed. I mean, very expensive, vacations, private plane rides, the purchase of a motorhome, none of which was disclosed to the public. And which caused Justice Roberts, the head of the Supreme Court, to say, you know what, we're going to police our own, and we are going to impose our own code of ethics, because he was just aghast at the fact that Congress was going to impose that on them. And so now they have to, if they accept any gift, they have to actually register that, which is a good thing, But So I think that what's going to happen is, and I don't believe that Biden has decided what he's going to recommend, but people do believe it's going to include a code of ethics that each justice is going to be bound by. And they are going to suggest term limits, anywhere between 12 and 18 years. Now, interestingly enough, if you look at everyone who has been a Supreme Court justice in the history of this country, the average time that each of those justices has served is 16 years. So, between 12 and 18 is kind of right in the wheelhouse of when people serve. And, I think if you ask the general public, when you got your first job, were you told that you're going to have this job for life? Guaranteed pay, no oversight? They would say, what? Sign me up for that. So I think people, the public, I think they're ready to consider real substantive changes. The issue is, will Biden even be able to get it done? And he's just not going to be able to get it done with basically a 50-50 Senate and Republicans in charge of the House. It would need a 2/3 vote. Whatever he proposes, whatever bill he proposes, would have to be voted on.
Explain why 2/3.
So, because basically you are making an amendment to the Constitution. You have to get 2/3 in the House and 2/3 in the Senate. Now, if you can't do that, then you have to go the route of like what we tried to do with the ERA, which has to be like voted on by the states, ratified by 3/4 of each state, which was never done with the Equal Rights Amendment. It's a very high bar to meet. And I just, again, if you are going to get it done on the congressional level, which is well within Congress's right to do, as stated in Article 3, it would take a supermajority in both houses, because 2/3, it's not just like one, it's not a majority. 2/3 is a lot. And so let's see what he comes out with. Again, Biden has said he is against court packing, because where does that end? I mean, how many justices is it going, is enough? I mean, are you going to have 50 justices on the Supreme Court? The goal is to, I guess, make it more fair and allow there to be some level of transparency as to who these judges are accepting gifts from. I mean, that is critically important, because some of the people who were gifting Justice Thomas had issues that were before the court. And that is something that the public clearly should know. So I don't know what you ladies think about this, but this is something I'm glad to hear that he is doing this, because, of all these recent decisions that the Supreme Court has come down with, I think it has brought a level of public consciousness that we haven't seen in a really long time, which I think is a good thing if we can start to even just have the conversation and then decide where to go from there.
I mean, I agree. I wish this had been discussed way sooner, because now it obviously looks reactive, and you're only doing it because you don't like the outcome. But I mean, this is just atrocious what the Supreme Court has been getting away with. As you said, Justice Thomas, with all the lifestyle and gifts that he's received, and Justice Alito, who's clearly biased with his upside down flag and et cetera, and that they don't have to recuse themselves from these cases at a minimum, right? They can just do all of this without any consequence. It's just so interesting that it's the nobody's above the law concept doesn't seem to apply to the Supreme Court, and it doesn't seem to apply to the president. It does apply to members of Congress, which will be a great segue into the Menendez case. But before we go to an ad break and then talk about that, Danya, is there anything you want to share or chat about this important topic?
No, it's nice to have complete unanimity here, right? We're like the Supreme Court, and just we all on this panel agree. It is disheartening, right, to see the high court, right, the highest court in the land, which oversees every criminal case, every case that they grant certiorari on. And everyone else has to adhere to the law, but they don't. And there's no mechanism. There's no safety valve. There's no mechanism for supervision. And I mean, I'm just talking about one aspect, obviously, of these reforms, but it's one that has been so in our face. I mean, you have evidence of clear bias, as you pointed out, Karen, with these upside down flags that only can mean one thing. And the gifts, that at least two justices that we know about have taken, and the effect that can have on decision making. It's truly disheartening, just as a citizen and a court watcher. So I agree wholeheartedly with you too. These reforms have been a long time in coming. It's sad and unfortunate that the Chief Justice isn't doing anything about it on his own. So at least we'll take a stab. And I also agree. I think with your assessment, it's not likely to go anywhere too far.
I don't think it is. And, again, just the bipartisan commission that President Biden set up, they came out, they didn't make any recommendation for structural changes. They didn't suggest pack the court. You have the ability to put as many judges on as you want whenever the court is going too far one way or the other. They didn't suggest any structural changes like that, but they did address the issue of term limits. Now, we have term limits for the president of the United States. Why do we have that? Because there was a president named FDR who served longer than any president and was the reason why we now have term limits, because we did not break away from a monarchy to install a new one here. We wanted there to be the ability for people to choose other leaders. And so if you can do that on the political level, we haven't had the political courage, backbone to do it for the members of the House and the Senate yet. Although I do think that will come up, especially given what we talk about with Menendez. But I think these are more than reasonable suggestions, and they should be taken seriously.
So we're going to just take a really short break for our pro-democracy sponsors who we love, because they're the reasons why we can be on the air and stay on the air. So stay with us while we go for a short ad break. Let's face it, after a night having too many drinks, I don't bounce back the way I used to, for sure. So I either have to make a choice. I can either have fun with my friends or have a good next day. That is until I found Z-Biotics. This is a probiotic invented by PhD scientists to tackle rough mornings after drinking. I don't want to look puffy. I'm on TV all the time, or I'm doing a podcast. So here's how it works. When you drink alcohol, it gets converted into a toxic byproduct in the gut. And this byproduct is not dehydration. That's not the only thing that's to blame for your rough next day. Pre-alcohol produces an enzyme to break this byproduct down. And so this is a proactive solution that wards off feeling miserable the next day instead of a reactive approach like drinking electrolytes or eating greasy food, also something I don't like to do anymore. So every time I have Z-Biotics before I drink, I notice a difference the next day. Even after a night out, I can confidently plan on being able to appear on television without worry. So admittedly, I was a little skeptical at first, but then when I was hanging out with a friend and having a couple glasses of wine, I gave it a shot. But now that I've tried it a few times, I know it works. And so I absolutely love Z-Biotics. And it's something that I will use if I'm going out to dinner and having a couple glasses of wine. So it shouldn't depend on whether you're on vacation, going to a wedding, birthday party, reunion, dinner, like me, anything. Get the most out of your evenings out and join the movement of people like me who are choosing Z-Biotics for smoother mornings and unstoppable success. So enhance your mornings with Z-Biotics. Go to zbiotics.com/MissTrial to get 15% off your first order when you use MissTrial at checkout. That's with 2 S's, by the way, MISS trial, no space. Z-Biotics is backed with a 100% money back guarantee. If you're not satisfied for any reason, they'll just refund your money, no questions asked. So remember to head to zbiotics.com/MISSTRIAL and use the code MissTrial at checkout for 15% off. Thank you so much, ZBiotics, for sponsoring this episode of MissTrial. This summer, do you want to enjoy hemp products but don't know where to get them? Are you in a state where it's not legally accessible? Had enough of overpriced dispensaries? Whether you're lounging under the sun or exploring new adventures, Via's premium hemp products are your perfect companion. They're farmed and crafted with care in the United States and trusted by over 500,000 customers. Via Hemp has a product for everyone. Their wide range of premium gummies covering all effects and strength ranges has you covered. Whether you're looking to set the mood in the bedroom or chill out after a long day, lab tested and certified, Via Hemp's products are sourced from the finest hemp for your peace of mind. Via is well known for their premium THCA flower grown indoors in state-of-the-art facilities and harvested at peak THCA levels to emphasize a natural aroma and flavor. The THCA flower strains are grown with care and rigorously tested to ensure the highest quality, free from harsh pesticides or nasty chemicals. And the best part? Via legally ships to all 50 states in discreet packaging directly to your door with worry-free guarantee. No medical card is required. So if you're 21 or over, check out our link in Via's website and in our description, and you can get 15% off. So you will, I think, like it if you try it, if this is your jam. Unlock the power of nature this summer with Via's organic and vegan hemp extracts, perfect for relaxation and rejuvenation. Via is the only lifestyle hemp brand. They use compounds found in hemp along with active plant extracts to create products, each with a specific effect in mind. Again, whether you want to get better sleep, ease anxiety, enhance your mood, or just feel a little something something, Via is for you. They also have 0 THC products. If THC isn't for you, you can still take advantage of their CBD line. So their products range from 0 to 100 milligrams of THC, and these guys have you covered. They're an industry leader, over 500,000 customers served, made in the USA, and award-winning. They have quality ingredients, and they're affordable and accessible. So if you're 21 or over, check out the link in our description to Via. Use the code MissTrial, that's with 2 S's, MISSTRIAL, to receive 15% off after you purchased. They will ask you where you heard about them, and if you support our show, tell them we sent you. Again, put MissTrial, MISSTRIAL, to receive 15% off. We're back to talk about 2 more topics. I'm really excited to talk and hear what you have to say, especially Danya, about Senator Bob Menendez's big conviction, because that just was a shocking case when it came in, right? He's the senator from New Jersey. He's the senior senator from New Jersey, and he was found guilty on all federal charges for this corruption case. It was bribery, extortion, wire fraud, obstruction of justice, and acting as a foreign agent. I mean, and the evidence in this case, like there were gold bars. Imagine as a prosecutor having gold bars as evidence that you can, put out on the table and just leave there to show the jury. If there isn't anything that screams bribery than a gold bar, I don't know what is. It's probably the single best evidence I've ever heard of. But this is a huge blow to the Democrats, right? He's a Democrat, and what the reason I wanted to talk about this case, and the reason I think it's important that we talk about this case is the difference. There's a huge, stark difference between the Democrats and the Republicans for the following reason. Democrats actually believe in the rule of law and playing by the rules, and of the whole concept of nobody's above the law. And so Chuck Schumer, the New York senator, who's high up in the Senate, I think he's the Senate majority or minority leader.
Majority leader.
He for now.
Sorry. Yeah, Senate majority leader. Yeah, exactly. For now, yeah, it's like he called for Menendez to step down, and that struck me as.
And he did step down as chairman of the fact he was on he was the chairman of the Foreign Relations Committee.
Crazy.
And is now convicted of having acted as a foreign agent. It's truly mind-boggling, mind-breaking. But yes, he asked him to step down, and he did.
Yeah.
So that is,
I mean, that is one thing that they can, and I think both parties try to do this whenever they have someone who is chairing a committee or ranking member of a committee, which is the party in the minority. Their top committee person is called the ranking member versus, being the chair. At the very least, if they're under indictment, they're asked to step down from that. But that still meant that Senator Menendez could still get briefings, including very sensitive national security information, while he was awaiting this trial, which I think is outrageous, which is a rule that has to change within the caucus on both the Democratic and the Republican side. And I think it's also important to remember that this is like deja vu all over again, except he got convicted this time. There was another case where he was tried for taking money and gifts from a good friend of his who was an ophthalmologist, and he helped him get very favorable things for his medical practice, and he got visas for his girlfriends.
No gold bars.
Yeah, no gold bars there, just visas for girlfriends, which is, saucy enough, I guess. But that was a mistrial, and they decided not to try that case again. And here he is 6 years later, now standing convicted.
Yeah, convicted, as Karen said, on all counts, 16 counts of incredibly serious conduct. And, everyone always talks about what the statutory maximum sentence is, which is not really useful metric. Here, what is going to drive the sentence is going to be, the amount of money. Here it was almost $500,000 in cash. And then, of course, the famous gold bars, and there was a luxury car. And so all that's going to be added up. And that will be one of the drivers of the sentencing guideline range, which is advisory and not mandatory on the judge, which we can talk about. But then there'll be other aggravating factors, including that he abused a position of trust. And so, Senator Menendez, who is 70 years old, I believe, is facing several years of serious federal prison time. Now, he's obviously going to appeal it. His lawyers have already said that. And the Supreme Court in particular has been very open to arguments from criminal defendants who have been convicted of public corruption charges. They have reversed many charges for honest services fraud, which is generally how corruption is tried. And they have significantly changed the goalposts for what is criminalized now. But here, as Karen said, this is as stark a case as you can imagine, literally trading, information, not just favors, right? Which, in the past, the former governor of Virginia was convicted of it, and several other politicians in recent years. But this is, tangible things, right? And as Karen has said, nothing more tangible than, gold bars in a suit pocket or suit lining. So I think, look, if somehow, some way this court, and he's a Democrat, so they'll be less apt, I think, to reverse. But, if they find some way, then political corruption is all, all full steam ahead, no hold barred, go for it, trade your office for money or gold bars or luxury cars, that's fine. But I don't think any court is going to find a way. And look, I don't know all the nuanced legal issues on appeal. Sometimes even a faulty jury instruction, can be the source for an appeal. But here there were so many charges and so much proof that even, if there's some nuance that honest services fraud, doesn't stick, some of the other ones assuredly will. And so this was a very significant conviction. And
I'm reading the press release just to kind of see what some of the conduct was. And it's so outrageous because of what you said, Danya, how the Supreme Court has been really limiting what can be bribery or what can be political corruption. Even just this term, a gift is, after the fact is not bribery, is what they essentially ruled, which is so bizarre. So if you pay someone after they did you the favor, as opposed to before, that's okay. I don't get that one at all. But here, what the indictment says is that when Menendez met his current wife, in 2018, Nadine, she worked with another person to introduce Egyptian intelligence and military officials to Senator Menendez. And those introductions helped establish a corrupt agreement in which they essentially bribed Senator Menendez and his wife in exchange for his actions to benefit Egypt and others, another co-defendant named Hannah. And as part of the scheme, Menendez gave sensitive, non-public U.S. government information to Egyptian officials, took steps to secretly aid the government of Egypt. I mean, this is just stunning, right? What he did, as you said, because he was privy to so much information because he was head of the Senate Foreign Relations Committee. So this is talk about a person in power who took advantage of his position. It's just unbelievable. And in return for this, he got just, the gold bars. He got $500,000 in cash. He got they got envelopes cash stuffed in envelopes and hidden in closets and closings in the safe. I mean, unbelievable. Like, this is something, this is so like cliche in a way of what you would see, and such good evidence that if you had written this in a screenplay, one of my other jobs is, I'm the legal tech advisor for Law and Order. If I had read this in a screenplay, seriously, I'd be like, come on, guys, you could do better than that. Nobody stuffs money in pockets and clothes and has gold bars. Like, that's just too obvious, but here it is.
But to your point, both of you have made this point that, let's see if this is upheld on appeal. I mean, you can't imagine a case that is more deserving of a conviction, I would argue. But in the hopefully unlikely event that the conviction is overturned, it is incumbent upon Senator Schumer to do more than just call on the senator to resign. He says he's running as an independent. He did not get the Democratic line. The election obviously is in November. His term is until January if he chooses not to run. But if he doesn't step down, the Senate Ethics Committee has already said that they are going to speed up their investigation. They opened it up when he was indicted. They have, I would argue, they are notoriously slow to act. I think they were waiting to see what happened because the last time it was a mistrial and he came back totally vindicated. But it's going to be critical that they take the steps to not even forget about censuring him. That's when they make you come to the floor of the Senate and they wag their finger at you and just say, you're a bad boy, don't do that anymore. It's expulsion. And that's going to take a 2/3 vote of the entire Senate. And I will tell you, given the number of forget about Republicans, they're all going to vote to expel him. I don't think they're going to have any problem getting, nor should they, having every Democrat say, it's enough. He was in the House first, and he's had a 31-year career in both the House and the Senate. It is enough.
It wouldn't be an impeachment. It would be.
No, what they would do is they have to get a recommendation from, this is what they did with George Santos. They had the Ethics Committee, which is a bipartisan committee. They made the recommendation for a vote to remove him. And that's brought to the floor of the House and it was voted and it passed. That was just a majority. I believe in the Senate, they need a 2/3 vote to expel someone. So, but they have to, look, you have to be able to, here we are saying that the Supreme Court needs to be policed. If we can't police our own, what credibility do we have? And what kind of trust can the public have that we are going to root out those people who run for public office? As Damian Williams said, this was a case of politics for profit, plain and simple. He has used his office to line his pockets.
Kathleen, just a quick question. I'm so curious about this. There's an actual investigation that needs to happen even after this resounding conviction?
Exactly. I mean, even for a committee that is notoriously slow, all they have to do is look at the indictment and say, okay, yes. And the jury knows saying guilty, 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 guilty. So, I mean, they said they technically have to consider, because, if you remember that when they did this to Santos, they said they actually came out they made the document public and said, beyond what has been reported in the public, he did all of these other things. And so they don't even need to do that here because Santos obviously hasn't even had a trial. This trial has been done. A jury of his peers have spoken and it's a conviction. So they're saying they're going to investigate it, but I think it's just getting it together. I hope they're not going to wait to see if he's going to be sentenced and is going to be able to stay out pending appeal. I hope they're going to move to expel him before then.
And
Wow.
is there, has he said whether he'll resign if he's convicted, or I know he's been quite defiant.
He has been so defiant, Danya. I mean, he said, I'm still running again. And the Democratic Party supported Andy Kim, who was a colleague of mine in the House. He is now the Democratic candidate for the Senate seat. He then said, I'm going to run as an independent. No one knows if that's serious yet, but he is like, this is all he's got is this job. You know what I mean?
He's not kind of hubris. Well, now that he doesn't have his side hustle, selling information. Wow. Well, that again is depressing, but at least the justice system worked here.
Yes. Very well.
So I know we're running out of time, so maybe we can turn to the Georgia case now. And it seems like we're jumping around a little bit. We have so much to talk about, and we've left some breadcrumbs along the way as we've been talking about the appearance of propriety, and of course, delay in cases, thanks to some of these legal issues and non-issues that somehow are elevated to issues. But here, the Georgia case, just to remind folks, because it really hasn't been front burner news, that has been a long simmering case, which was a case brought by District Attorney, Fulton County DA, Fani Willis, who charged Trump and many others with various charges that relate to their attempts and racketeering conspiracy to overturn the results of the 2020 election in Georgia. And a number of defendants were co-defendants of Trump's were also indicted, including 4 advisors and lawyers who already have pled guilty. But the proceedings have been delayed for a number of reasons, but mostly because several defendants moved to disqualify the district attorney once news came to light that she had a relationship with a special prosecutor by the name of Nathan Wade. And the judge in that case held a hearing with really some very stunning testimony, but he issued a very well-reasoned and deliberate opinion some time ago, essentially saying, look, I'm not finding that there was actual bias here, because the argument was that, the cards were kind of stacked because she had this romantic relationship with a special prosecutor who was in charge of the case, and that motivations therefore could be questioned. He said, I'm not finding actual bias, though he did say that he believed that there was at least the appearance of that, which will be a decision or a component of the decision that will be highlighted, no doubt, to the Court of Appeals, which we now know, I think today it came out that the oral argument for that is set for December. So that's on a slow burn. I think it really was a well-reasoned decision by a distinguished jurist there, and we'll see what the Court of Appeals does with it. But there was some testimony that the court said he was not finding that anyone lied, but he found some of the testimony disquieting at the very least. And so that will go to the Intermediate Court of Appeals to be argued in December. And then, of course, either side can appeal that to the Supreme Court in Georgia. So that's going to be, again, it's going to be a long time in coming before we get a decision there. And then, of course, there's going to be the fallout from the Supreme Court's immunity decision, about which we have discussed, a lot, and much ink has now been spilled. But there are going to be arguments there that decision should impact the prosecution here, that some of those acts that are in the indictment were official acts, even though I think what flies off the page, in the 4 corners of the indictment, is that the acts in question, for example, certain famous calls to state officials in Georgia looking for more votes, that those were done as candidate Trump and not as President Trump. But the arguments, of course, will be made. There may be hearings there. And so that's going to travel up and down the circuit and going to further, throw sand in the gears, the wheels of justice. So, that's one to watch. But one good piece of news about that I think people need to keep in mind is that this is a state case. This is not a federal prosecution. And so, dare I say it, but, should there be a second Trump term, he's not going to be able to stop it in the same way that he will with the 2 federal cases against him. Well, one has now been dismissed, so we'll see. We'll see what happens. There may only be one federal
Yeah,
case.
well, he definitely can't pardon himself, that's for sure.
Correct.
Nor can he dismiss the case if he's president, for sure. But I do want to remind everybody, because we dealt with this as a state court prosecutor, Kathleen will also remember this. We were stuck with that little pesky thing called the Supremacy Clause in Article 6, Paragraph 2 of the United States Constitution that establishes that the federal laws and treaties are the supreme law of the land and take precedence over conflicting state laws. So the reason I mention that is because whatever Judge Chutkan says, he's immune, when she goes through the analysis, since a lot of the conduct is the same, whatever Judge Chutkan says, I think Scott McAfee, the judge in Fulton County, Georgia, is going to be hard pressed to not, find the same thing. There's a lot that is Georgia specific. Obviously, there's a lot of other defendants in this case that have nothing that aren't Donald Trump. I think 17 other defendants. So there's still a lot of case left. And even if he is elected president, it'll be interesting to see if the rest of the case gets severed off and gets tried. But the case is in total question mark land of what's going to happen because of the reasons you just pointed out. So anyway, but it's just it's a strange world we all live in. And I go back to just how many people said, why did Alvin Bragg bring this case? Why this case? Why is this the case? And you know what? It might be the only case. And it's certainly the only one, at the end of the day, Donald Trump has been convicted of 34 counts. He has committed 34 crimes. And that, for even if nothing else, history will always show that a jury a jury of his peers that he chose found him guilty of crimes. And so I think the history books for our great grandchildren, at least in one of the instances, the accusations were removed from the world of politics and were put before a jury where witnesses were cross-examined, had to swear under oath, and he was found guilty. So, and that means something. And so for that reason, I'm proud of my old office.
As well you should be.
And I'm proud of my client, Michael Cohen, who withstood pretty withering cross-examination, but at the end of the day, stood up and
he really did.
Yeah.
He's going to go down in history as being one of the heroes. Seriously. I mean, it's interesting when you think about who those individuals are. And I know a lot of people dislike Liz Cheney for her politics, and I disagree with much of what her politics are. But she will go down in history of one of the people who decided to stand up for what's right. And
when he was president too, when he was president.
Yep. Him, Adam Kinzinger is another one. And, even Mike Pence, who, again, people say, why are you applauding him? He did his job. He certified the election. But, not a lot of people will stand up to Donald Trump. And I want to at least acknowledge those individuals who have, and Michael Cohen's going to be another one who I think is going to go down in history as someone really, really important.
Well, I think that, that term speak truth to power is so overused. But when you think about it, like how many people, have actually done that? And I think Michael Cohen is one of them. I mean, Donald Trump is inarguably one of the most powerful people in this country, even out of office. And, I think it should not be lost on people how hard it is to stand up to someone like that at great personal expense, just because you think it's the right thing to do.
Well, it's good to end on an upbeat note. I think we've all been a little depressed so yeah, there's good in the world, and there's strength of character, and the resistance lives on.
Great to see you, ladies. We've reached the end, and I love doing this with you, and it's good to see you.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.